Mildred Shannon versus Rebecca Wyatt, 45 CO1 1505 MI 90. Who's here on behalf of who?
I'm Attorney Mildred Shannon. I'm here on behalf of Petitioner Mildred Shannon.
Okay.
Your Honor, Justin Murphy, they entered appearance on Monday on behalf of Ms. Wyatt.
Okay.
And Jim Weezer on behalf of Lake County Board of
Okay. All right. We're here on what? A motion for continuance?
The petition for extension.
Okay. Is there an objection?
Your Honor, I did a better appearance on Monday. Yesterday, I filed trial rule 5 an objection to the request for an extension of time. I filed a motion to dismiss based upon their failure to complete the recount within the statutory time. And then I also filed a motion to dismiss for lack of subject matter jurisdiction. And so, since those motions were filed, I would believe that the motion for lack of subject matter jurisdiction would be heard first procedurally. I did send it to the court yesterday by fax. I was told by the court when I entered appearance on Monday and that this hearing was set today that I should feel free to do so. At the time that I did that, I also faxed a copy to the petitioner's attorney. My understanding, she had some problem receiving it. My office talked to her office twice yesterday and was successfully sent to her yesterday. And I also sent a copy to the attorney for the election board yesterday. So today, before you, on behalf of my client, there's a motion to dismiss, claiming that this court lacks subject matter jurisdiction. And I also have the motion to dismiss.
Your Honor, we would object to the motion to dismiss as well as to the objection, and the basis of that is that neither of the time we filed. The petitioner and the respondent had until, I believe it was June the 19th, to in fact 20 days after the filing, to enter her appearance and file a motion, objection, or anything. She did not do that. That was not filed until yesterday, and so we absolutely requested that was stricken from the record.
Your Honor, if I may then respond. For one, on the matter of the subject matter jurisdiction of the court is something that can be raised at any time. It can be raised at the trial court. It can be raised upon appeal, so it is timely before the court. Also, there is no statutory or trial rule to support what the petitioner's attorney is alleging in this particular matter. This is a matter of a recount. There is no requirement to file a responsive pleading. There is a deadline to file counter petitions, which we have not done. So there is nothing whatsoever to support her argument. This motion is timely before the court. As I said, a motion for lack of subject matter jurisdiction can even be brought up at the time of an appeal. So I have entered my appearance, and so did Ms. Wyatt, the respondent, on Monday, and this is timely before the court.
Your Honor, of course, we would object to that, and the statute is very specific as to how much time the respondent has to file.
File what? A response?
Has to file a response, a motion.
Was there a response of pleading?
An objection, even entering their appearance. There is a 20-day period. Otherwise, there would be no need to have a 20 days to file it.
I would challenge her to tell you what that state statute is, because there isn't such statute.
Do you have that cite?
Yes, sure. Well, I will pull it up on my Apple. Because I just received this upon walking into court today. So, but I will pull it up on the actual.
In fact, Your Honor, in the recount statute, it specifically says that no affirmative or no responsive pleading is required.
It says that what the statute specifically says is that there is not a presumption of admission to the filing of this. It says there's no presumption, but it does not say that it's not.
Wouldn't the burden on you challenging the election?
On me, the petitioner? Your Honor.
I mean, they don't really have to do anything, do they?
No, they don't. But for them at this late point to actually file a motion to dismiss on the date that we're requesting a petition, we're requesting to have the matter extended, would clearly put the burden on them for them to file it this way. But be that as it may, as it relates to our motion for extension, which is what was set today, the reality is the court specifically in Indiana Code 312.621.9c, the court has the ability to grant an extension based upon good cause. It is our position that the petitioner has good cause for this extension. And what has happened? What has happened? And as a matter of fact, our position as well is that for Ms. Wyatt to even object to the extension is not an argument that is in good faith. We filed the petition timely. She was served timely. We even though she had not entered her appearance, had not done anything, we worked with her in order to come up with the commission. We prepared the stipulation. She objected to the party that we had. We accepted the person that she wanted to include on the commission. I drafted a stipulation. She signed the stipulation. She then contacted me shortly thereafter, actually on the 24th of June, and she stated there had been an error. And she requested that I correct that. I listed that there were 19 precincts and there was only 18. She told me to file a motion to change it. I filed a no-content motion to change that one line in it. We then worked with Attorney Weezer in order to coordinate a new date. Attorney Weezer, the only date that he had on his calendar that was available was June the 24th. There was previously a recount, I believe, for the East Chicago map on that day. That date did not work with my schedule, and Attorney Weezer actually advised me that as it related to his schedule, because the afternoon was used for the 5 precincts for East Chicago, that there's no way that we would be able to have the recount of the 19 precincts. We then, all parties agreed that we would do it, all parties of record, agreed that we would do it the first week of July. When I came back, because I was on vacation, we sat down. I attempted to contact Ms. Wyatt. I got Mr. Weezer, Attorney Weezer's schedule. I gave her several days to choose from. At that point, she advises me that she's represented, she had retained Attorney Murphy. That was the first conversation I had with her. Our position is that clearly, not only did she not enter her appearance, but she actively worked in the process. And in fact, hindered the process in that she requested that I do a no-content motion. And now, at the 9th ending, she's going to object to the extension. We are requesting that there is clearly good cause. One, because of the fact that the schedules did not allow us to have the recount prior to the 26th, which was the first Friday in June. 2, that we had the stipulation. We worked together on the commission, on selecting the commissioners. So there's clearly good cause because A, like I said, we had worked on it. There was a conflict in schedule, and so our position is there should, in fact, be an extension. We agreed on it. There is, and the court has the authority to do so because there is good cause.
Okay. Murphy.
Judge, I would again stand by my motion to dismiss for lack of subject matter jurisdiction. The argument that I brought to you saying that you don't have subject matter jurisdiction goes to the manner in which the petition was filed. The petition's not verified, it's not under oath, it's not under the penalties of perjury, it's not stamped by a notary, the oath wasn't administered in front of a notary. The case law is real clear that if that's not done, this is something that's required by law to be verified. She would either have had to comply with Trial Rule 11B, and then there's language that she would specifically have used, which they did not do, or she would have had to say that it was under the penalties of perjury in front of a notary, which they did not do. So I have filed a motion to dismiss for lack of subject matter jurisdiction because this petition is not properly before the court. If they had filed it properly, you know you have jurisdiction. So it's not properly filed. My client can raise the lack of subject matter jurisdiction at any time. I was hired on Monday. I picked up the court file on Monday. I filed this thing within 2 days. And I had to have the court file to find out that it wasn't properly verified. And so that's properly before the court. With regard to her request for an extension of time, we object to the request for an extension of time. There is nothing in the record that shows that the petitioner used any diligence whatsoever in prosecuting this matter. This is an election matter. By statute, it is to be accomplished within 36 days. Consider reading of the statute. The statute says that after election day is done, you have 14 days till noon to file a petition. You have the same amount of time to file a counter petition. In the old days, it used to be 7 and 14, but now it's 14 and 14. After the end of the 14 days, this court has the power to appoint the recount commission. And then at that time, that recount commission has 36 days to do their job. Now, in this case, the petitioner didn't do anything to get the commission appointed. The record reflects that it was appointed on the 22nd. So that means they waited until 4 days before the deadline to even get the commission appointed. Now, it's the petitioner's job in an election matter to use due diligence to move this matter forward. And from the period of time that they've had, it's clear from the record that they did not do anything to comply with that. Even when this thing was ordered, she still had 4 more days to do it, and it still wasn't done. So this recount could have been timely accomplished. It wasn't. There was a case before this very same court called Smith v. King, and it was an election contest, not a recount, but they are both election matters. They're both very similar. The law treats them nearly the same. In that case, it was a petitioner that was represented by an attorney here in Lake County, and he made the same argument that's being made right now, that there should be an extension of time within which to complete the election contest hearing. And in that case, there was an allegation by actually the attorney for Mayor King, Jim Meyer, I believe, made the argument saying that their petition was not sufficient. In that particular case, they had affirmed under the penalties of federal law that the matters alleged in the petition were true. This court did dismiss the case on that matter for that reason. However, at the same time, the election board objected to the extension of time, just like what is being said right now, saying that no exceptional and extraordinary circumstances have been proven. Now, in this case, there's no exceptional or extraordinary circumstances that have been offered to the court. If there's 36 days to conduct the recount, there's a bunch of parties and lawyers involved, and you got to get your schedules together quick, and you just got to get it done. You can't wait to the very end. So, just like Smith versus King, there's been no showing of extraordinary circumstances. In this case, they had 36 days to do it. They didn't do it. They just didn't get it done. So there's been no showing. With regard to her request for an extension of time, it says in the law that in order to, in fact, it says it in the statute, in order to be granted the continuance, there must be a showing of good cause. There's been no affidavit that's been filed with the court. There's been no evidence that's been offered to the court today. So I would stand by the cases I cited to the court in our brief, simply saying that there is no good cause to justify the continuance either. So we would ask you, number one, to dismiss because there's a lack of subject matter jurisdiction. The petition is not properly before the court. Secondly, we do object to the extension of time for the reason that it could have been timely completed, but it was not. There's been no showing of extraordinary or exceptional circumstances. And then finally, there is another second motion to dismiss before you, to dismiss because they failed to complete it within the statutory time period. So for all of those reasons, we ask that you dismiss.
Your Honor, just very, very briefly, one, if Your Honor look at the petition specifically says that Mayor Buchanan does hereby solemnly swear and affirm that the aforementioned statement.
All right, so why don't we do this? I'm going to give you 5 days to respond to this motion to dismiss, and then I'll rule on it since it's been filed. just recently should have a chance to respond to it.
You want me to file a reply to the response?
If you wish,
You give me 2 days.
2 days after that.
Your Honor, the only issue that we have is there is definitely a time constraint because of the fact that the machines have to be recalibrated and all of that. Specifically, when Attorney Murphy argued that in Smith versus King, that was his basis for requesting the denial. As well, very briefly, I will say that in the case of Smith versus King, it was a completely different issue, and they were requesting 60 more days for discovery. We're just requesting 5 days.
Mr. Weiser?
Your Honor, if I just could try to add something that I hope to clarify the position of the Lake County Board of Elections and Registration in this matter, because what Ms. Shannon represents, Ms. Shannon Lewis represents to you is pretty accurate with one exception. And that is that when we had a discussion about the extension of time, because initially when Inga and I talked, she was not aware that there was a statutorily imposed deadline. And I advised her that there was, this was probably the second week of June or so. And I advised her that there was, and I pointed her to that section, and did advise her that if she needed to file a petition for cause, extension of time for cause, she could do so. So, to follow up, first of all, the East Chicago recount was done on Tuesday the 22nd. And what I did, and I sent an email to Inga on the morning of, Tuesday the 23rd, and I said I would not have a problem extending the recount date, but in order for that to occur, you would have to file a petition with the court on or before this Friday, which is June 26th, per IC 3-12-6-21.9C for such an extension. And that was because I knew the extension had to be filed by then under the law. So to the extent that, and no such extension was filed. I understand, in talking to her, that apparently what happened is she had dictated it, she had prepared it, but for some reason her staff didn't get it filed with the court. So I contacted her several days later and said, look, I'm going to have to file a motion to dismiss after that Friday because you never filed a petition for extension of time. And she filed a belated petition for extension of time, I believe on June 30th, and said, well, we had an agreement. I said, well, we had an agreement to the extent that my email and my conversation with you was that as long as you filed that petition on or before June 26th, because that's the statutory deadline. And so that's why I can't, even though I acknowledge that I had conversations of that nature with Ms. Shannon Lewis, that wasn't the agreement or understanding we had. My understanding and my agreement was file a petition on or before Friday, June 26th, and I won't have a problem and I won't object to it. But if you don't, and impliedly, and I probably should have said it specifically, but impliedly, I was saying if it isn't filed by then I will have an objection to it. So that's the position of the board.
And if it's not filed by then, what does the statute state?
The statute says, Your Honor, and the title of the statute is recounts, deadline for completion. That's the statute, the section. And it says, except as provided in subsection C, which is the good faith or good cause, a recount for nomination to an office conducted under this chapter shall be completed not later than the final Friday in June following the primary. That's the deadline.
Okay.
So, and in this particular case, that constituted Friday, June the 26th.
And that would have to be the motion for extension would have to be filed
by that time.
By that date.
That's correct.
Excuse me, if I may. It does not specifically state that the petition for extension has to be filed at that date.
But if the deadline passes and there's no extension filed, what's the effect of that?
Specifically, it says in section C that the court can grant the extension for good cause. And so our position is that there's clearly good cause in that all parties had, one, agreed that there would be an extension with the exception of my read of the email was obviously incorrect, because my understanding is that there could be an extension to the entire basis, or the reason that it had taken so long to get filed is because Attorney Ms. Wyatt or Attorney Wyatt and myself were trying to come up with who the commission could be. And then, not only had I prepared the petition for extension, but I prepared that as well as a LakeCo order. And it happens that my staff filed the LakeCo order before it filed the extension. And that was certainly a scribbler there, and it's our position that it was unexcusable.
When did you file for the extension? On what date?
We filed for the extension. It would have been, I believe, the 30th, whatever the day is that I talked to counsel. So I believe it was
22 is what the record shows.
It was June 2nd. So I would have talked to July, that's right. It was July the 2nd when it was filed. As soon as I talked to Attorney Weezer and I realized that it inadvertently had not been filed for that day, then that's when I went ahead and filed it. And specifically, it is outlined in my request for a filing of a belated extension. It specifically states why it had not been filed, and that it was an inadvertent error, that all parties of record knew that it was going to be requested because we could not coordinate the payment.
Okay, well, I'll wait for your response. Yes, go ahead.
If I just respond to the arguments that have been made by the two of them, as I understand it, there was discussion between the two parties of record, that being the petitioner and the election board, concerning an extension of time if it was filed before the deadline. The election board wasn't going to object, but that wasn't done. So I think the implication is that the election board does now object. I don't know
That's what he said.
Yeah, I just didn't have time to file a response in terms of Ms. Burks, but we object because it wasn't filed in a timely fashion.
And so I understand that they object also, as well as do we. And I would only add to that argument to the court that even if they had these discussions, the failure to properly file the petition, still the case that I cited to you is State X. Rel. Howard versus the Lake Circuit Court. And it's a case where it said that the jurisdiction of the general subject matter of the proceeding and a recount of ballots for nomination for a particular office can't be waived by the parties. And so the fact that the election board did not file a motion to dismiss shouldn't prejudice our rights to file the motion to dismiss at this time.
All right, I will 5 days to respond, 2 days for, if you want to file some, Mr. Weezer.
Thank you, Your Honor.
Okay. All right.
All rise.